I want to now turn it over to Kerstin Henze over from our Tampa Bay office. Take it away, my friend.
Thanks, Jeff. That was a mouthful.
Yeah.
I just
Sorry.
kind of want to piggyback on what you said about the credits, because I get this question all the time. Why does this not satisfy credit for condominium board members? And that's simply because, the statute was changed several years ago and now clarifies, the type of continuing education credit that is required for condominium board members, which is different from the continuing education credit requirements for HOA. So the content of the continuing education course is different, and it's basically, a legal update, which is what the condominium statute requires for condominium board members, and this just does not satisfy that. So with that said, just a quick introduction. Again, my name is Kerstin Henze. I'm one of the attorneys with the law firm of K. Bender Rembaum. I manage the West Coast office for the firm, which is located in Tampa. We do have, other locations, with our main office being in South Florida, in Pompano Beach. But we also have an office in Palm Beach Gardens, as well as in the Orlando area. So if you're attending, from one of these other locations and need further legal guidance or assistance, feel free to reach out to the respective offices. We are an exclusive community association law firm, so that means we represent exclusively your condominium, your HOAs, and cooperative associations. We have about 26 attorneys throughout the state of Florida, and I've been practicing law 17 years and have been with the firm since 2010. So
So,
I've been
Kirsten,
doing this for some time.
yeah, since you were 10 years old,
Pretty much.
because we both look fantastic, right? So, hey, I just want to mention real quick, I have a few people in the Q&A. I failed to mention this. It will say chat is disabled for you. Don't worry about that. We can still send stuff your way. So just make sure the chat area appears. Don't worry that it says disabled. It's one way. We can still send stuff your way. For you guys to ask questions, you'll use the Q&A, which is much easier to monitor. If we were using the chat, it would just go way too quickly. Back to you, Kirsten.
All right. Very good. Can you see my slides, Jeff?
Yes.
Okay. So we're rock and rolling. All right. So we're going to cover today elections for condominium and HOAs. I'm going to, try to go through all these slides first, and then I will definitely stick around to answer some questions towards the end. Okay. But we'll just kind of run through the slides. All right. So we will start with annual meetings and elections for condominium associations, and then we'll transition to HOAs. Good. Okay. So with condominium associations, in terms of number of directors, the Condominium Act says that unless otherwise provided in your governing documents, a board of directors will consist of 5 members, except if you're in a condominium that has 5 or fewer units, then the board will consist of at least 3 members. Okay, so look at your bylaws. Typically, you'll have to look at your articles of incorporation and the bylaws together to determine the size of the board. Remember, the articles of incorporation and bylaws are the 2 set of documents that set out your corporate structure of your association. And this applies for condominiums as well as HOAs. But when there is a conflict between the articles of incorporation and the bylaws, it is the articles of incorporation that will control the issue, right? And so we don't want to look exclusively to the bylaws. We also always want to take a look at the articles of incorporation to make sure that there's no conflicting language with the bylaws. And typically, the size of the board is a provision that you will find in both the articles and the bylaws. Okay. Now, if your bylaws do not contain a valid method for determining the number or the size of the board, then your board will consist of 5. Now, determining the number of directors at the election is not a valid method of determining the number of board members. So, in other words, if you want to, modify the size of the board, whether increase it or reduce it, that needs to happen prior to the annual election meeting. Okay, and that will go for both HOAs and condominiums. In other words, you're not deciding the size of the board at the actual election. That has to be done in advance of your annual meeting. Okay, terms for directors. So the term of directors will expire at the annual meeting unless, okay, there are staggered terms, in which case the term will not expire until a later annual meeting, or if all director terms would otherwise expire and there are no candidates, in which case the existing board will simply roll over. Now, if permitted in the bylaws or the articles of incorporation, a board member may serve a term longer than 1 year. So typically 1 year, but the statute does not prohibit the length of a term. So if you want to allow directors to serve a term longer than a year, you may have to then amend your bylaws. Now, as of July 1st of 2018, a condominium board member may not serve more than 8 consecutive years unless approved by 2/3 of the members voting in the election, or there are not enough persons willing to serve. All right. So for many of you, this deadline is coming up, right? 8 consecutive years as of July 1st of 2018. So just be aware of this provision. Now, if the number of vacancies equals or exceeds the number of candidates, then obviously you're not going to have an election on the date of the annual meeting, and the directors, whoever submitted notice of intent to run, will simply be seated by acclamation. Now, in terms of eligibility, there's nothing in the statute that requires directors to be unit owners. Okay, that's a misconception. That's typically something that may be required in your governing document. Okay, so whether directors have to be unit owners, that will be governed by your articles of incorporation and the bylaws. Okay, if you currently don't have a specific requirement for directors to be unit owners and you would like that, then you will have to likely amend your articles of incorporation and bylaws to address that. Okay. Now, please be aware also that per Chapter 617 of the Florida statute, and this is the statute that governs not-for-profit corporations. So, your association is an entity. It's a not-for-profit corporation that is not only subject to 718, but it's also subject to Chapter 617 of the Florida statute. And this statute provides that if a unit is owned by a trust, okay, and that is very common for condominium units to be owned by trusts, right? Then the grantor of the trust, which typically is the individual owner that created the trust. So the grantor of the trust, as well as typically the occupant of the unit, or the beneficiary who resides at the unit, is eligible as a unit owner. Okay. Now, other eligibility requirements for board members that may be set forth in your governing document will not be valid. Okay, so they can subject the election to a potential successful legal challenge. A common qualification requirement that may be subject to legal challenge is one that I've seen often, and that is a requirement for directors to reside in the unit for a certain period of time, or at least be local, right? So you'd have to, reside at least 6 months out of the year at the condominium in order to be able to serve on the board. Those types of eligibility requirements will subject the association to legal challenge. So if you have them in the documents, you may want to consider amending them out. Now, since July 1st of 2021, the statute now provides that a person who is delinquent in the payment of any assessments due to the association is not eligible to be a candidate. The statute used to say that anyone who's delinquent in the payment of any monetary obligation would not be eligible to run for the board, but that has since been amended out. So it's not just any monetary obligation, it's limited only to assessments. Okay, so if an owner has not paid a fine that has been duly imposed against the unit, or has not paid any fees attorney's fees or costs in connection with any collection efforts, and they're reflected on the account ledger. None of those fees or costs are subject to this requirement. Okay, so limited only to assessments. Other eligibility requirements. Well, a person who has been convicted of a felony or who has been convicted of any offense in another state, which would be considered a felony if committed in the state, is not eligible for board membership unless the felon's rights have been restored for at least 5 years as of the date the person seeks election to the board. Okay, so they're not eligible to be a candidate. In a residential condominium association, which is different from commercial condominiums, if you have more than 10 units, then co-owners of a unit may not serve on the board at the same time unless they own more than one unit or unless there are not enough eligible candidates. And then the term requirement that a condominium board member may not serve more than 8 consecutive years unless, of course, approved by the affirmative vote of 2/3 of votes cast in the election, or there are not enough candidates. And this 8-year consecutive term requirement is effective as of July 1st of 2018. Now, the term candidate is defined as any eligible person who has timely submitted a written notice of intent to become a candidate, right? So with condominium elections, we'll talk about the notices and the notice, the timing of submitting notice of intent to run. So in order to determine whether or not an owner is eligible, the deadline, the cutoff time frame to determine that eligibility is as of the date that the deadline for submitting the notice of intent to run, okay, which is at least 40 days prior to the annual meeting, okay? So that's the cutoff date by which you need to confirm whether or not the owner is eligible, such as, whether or not the owner is delinquent on any assessments. Now, including ineligible candidates on the ballot will jeopardize the election. This is why it's important that you confirm the candidacy of the individual timely. So if a ballot includes the name of an ineligible person, right, then the Florida Administrative Code says that the association will then have to send out an amended second notice. Assuming there's even time to send out an amended second notice, which we'll talk about, the second notice has to be mailed out at least 14 days prior to the election. So if you still have that time, you will have to mail out or provide an amended second notice, which has to explain the reasons, the need for you to send out this amended notice, right? Which in this case, it's the reason being that, some ineligible candidates made it on the ballot, and now you're resending an updated ballot with the names of only eligible persons. Now, if the amended second notice cannot be timely provided to the membership, then you will have to renotice and reschedule the election, okay, starting with the second notice. If the election has already occurred, then just note that the election is deemed void and the association must renotice the election starting with the second notice. Okay. In terms of the timing of your notices in connection with your annual meeting, there's 2 notices that need to be provided of your annual meeting election, okay? The first notice, and it's called first notice, that needs to be provided at least 60 days prior to your scheduled election. Now, the notice must be either mailed, hand-delivered, or can be electronically transmitted to those owners who have consented to receiving notices electronically via email and have consented to do so in writing, right? So you need to have a written consent of some form from that individual. Otherwise, the official notification of the election would have to be either mailed or hand-delivered to those individuals, and then you can, of course, electronically submit it, but only as a courtesy. Okay. Now, Any owner who's eligible and wants to run for the board must then provide a written notice of intent to run at least 40 days before the scheduled election. Okay. Now, there's no specific, there's no requirement for an owner or a candidate to submit any specific type of notice of intent to run. So, I mean, they can easily they can put their notice of intent to run in a napkin, that's okay. The board can facilitate a form notice of intent to run, but an owner can certainly submit their own form. Now, upon request of a candidate, the association has to include an information sheet no larger than 8.5 by 11, which must be furnished by the candidate no less than 35 days before the election. Okay, so if you receive these information sheets, which essentially are a little bio of the candidate, right? Then you are going to have to include those information sheets with the second notice, which we'll talk about in the next slide. So then at least 14 days prior to your annual election meeting, you're going to provide owners with what is known as the second notice of election. Okay. And again, that second notice will have to be either sent by mail, hand delivery, or can be electronically transmitted to owners who have consented to receiving notices by email. That second notice is going to contain, of course, your date, your time, your location, and then the agenda items for your annual election meeting, which of course is going to include your election, and then you may have other agenda items as well. But at a minimum, it's going to have your election. That second notice also has to be posted in condominium property at least 14 days prior to the date of the meeting. Okay. And then the statute requires that the officer or manager who provided that second notice confirm or attest that notice was duly provided, and that has to be done by affidavit, okay, which you will keep as part of your official records. Right. The notice of the annual meeting also has to be posted on the website, right? So for condominiums, there was a website requirement in the statute for a number of years requiring websites for those condominiums with 150 units or more, right? That changed January 1st of 2026. That threshold now was reduced to 25. So now any condominium that has 25 or more units, you're subject now to the website requirement, and you hopefully by now have created an association website that is in compliance with Florida statute. I'm not going to talk about the specifics of the website requirements. Definitely get with your property manager if you have any questions. But if you fall under this requirement, you are now also required to post notice of your membership meetings, which would include the annual meeting, on the website at least 14 days prior to the meeting. The notice has to be posted in plain view on the front page of the website or on a separate subpage labeled notice, which is conspicuously visible and linked from the front page. You also have to post on the website any document to be considered and voted on by the owners during the meeting, or any document listed on the agenda at least 7 days before the meeting. So for example, if at the annual meeting you're going to be presenting to the owners proposed amendments to your governing documents, then those amendments would also need to be posted on the website. Electronic notices, I briefly mentioned this a few slides ago. Electronic notice, meaning notice sent via email or fax, for those who still have a fax, can only be sent to owners who consent in writing to receiving official notices by electronic transmission. Okay. The only caveat is that electronic notice cannot be used for the recall of a board member or for retrofitting the condominium with fire sprinkler system. This is different from electronic voting, which I'll talk about briefly in a few slides. Electronic voting refers to the mechanism of an owner signing on to a third-party platform to vote on a matter, right? We're talking about notices, not electronic voting. Go to the next slide. Okay. So in terms of the annual meeting and election, the date of, okay, there is no membership quorum requirement in order to conduct your election, right? The only thing the statute requires is that at least 20% of the eligible voters cast an election ballot, right? So as long as you have that 20% of the ballots, then you can proceed with your election. Now, caveat, House Bill 913, which took effect July 1st of 2025, so this past summer, now provides that if the annual meeting is conducted via video conference, then a quorum of the board must be physically present at the physical location where unit owners can attend the annual meeting. We'll talk about video conference in the next slide in more detail. But this is one of these new requirements imposed by the legislature, which honestly doesn't seem to make any sense. So, for annual election meetings, which are meetings of the membership, there has never been a quorum requirement, a quorum of the board requirement. But now the statute says that if you're conducting your meeting via video conference, right? So a Zoom meeting, for instance, where you have the ability to see one another, that would qualify as a video conference. Quorum of the board has to be physically present. I have not seen this issue being legally challenged or the division, making any determination on this particular issue. So if a quorum of the board does not physically appear at the physical location and somebody legally challenges this issue, remains to be seen how the division will address it. Now, if the meeting is conducted by video conference, be aware that the meeting will need to be recorded and the recording will need to be maintained as part of the official records. Now, while the election part of the annual meeting does not require a quorum of the members, if you have other agenda items set for this annual meeting, then any business other than the election can only be conducted if you have a quorum of the members present. Okay. No proxies can be used in election, ballots only, and we'll talk about ballots momentarily. So some other changes that took effect July 1st of 2025. If the bylaws do not provide the location at which the annual meeting must be held, the statute now says that the annual meeting must be held within 15 miles, used to be 45 miles, of the condominium or within the same county as the condominium property. The statute also authorizes now unit owner meetings, including your annual meeting, to be conducted in person or by video conference. And the statute defines what video conference means, and the definition is at the bottom of this page, which is defined as real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. So it's audio as well as video. Okay. Now, if a unit owner meeting is conducted by video conference, then there are additional requirements imposed by the statute, and those include that the notice of the membership meeting has to include a hyperlink as well as a call-in conference telephone number for the unit owners to attend the meeting. The notice must also include a physical location where owners can attend the meeting in person. So you are no longer allowed to have these, Zoom meetings without a physical location. Okay. For membership meetings that are not part of the annual election meeting, there is no requirement for quorum of the board to be physically present. Okay, so that requirement is only for your annual election meeting. And make sure you have a physical location. And then the video conference has to be recorded. So you're going to have to record those Zoom meetings. And then those recordings will now be required to be maintained as part of the official records. Okay. Now, verification of the outer envelope. So with condominium elections, as many of you may have experienced, right? You can't vote by proxy. You have to vote by secret ballot. And the secret ballot typically will go inside what is known as an inner envelope. And the inner envelope is then inserted into what is known as an outer envelope. And on the outer envelope, the owner has to identify their unit number and then include their signature, right? So the first part of any election is to verify these outer envelopes, right? And the statute provides two ways for you to verify these outer envelopes before you even open through the envelopes and start counting the ballots. So the verification can either be done in advance of your annual election meeting by an impartial committee, or it can be done on the date of the annual meeting. Now, for those condominiums, especially the high rises that have, hundreds of owners and you have a pretty active membership, verifying outer envelopes on the date of the annual meeting is probably the longest part of your election process, right? And so many boards may opt out of verifying on the date of the annual meeting, rather choose to verify these outer envelopes in advance or prior to the annual membership meeting. So the Florida Administrative Code provides a little bit more detail of how this process would work if you're verifying outer envelopes by an impartial committee. And it basically says that the association may verify the outer envelopes by noticing a meeting of an impartial committee consisting of members who are not current board members, officers, or candidates for the board or any of their spouses. So if you can get some volunteers, okay, and create this impartial committee, then you would essentially notice a committee meeting with notice of the meeting posted at least 48 hours prior to the meeting. And on the date of that meeting, the committee members will come to the location of the meeting and will start verifying the outer envelopes, right? So at the impartial committee meeting, the signatures and the unit number on the outer envelope will be checked against the list of qualified voters who will be checked off on the list as having voted, right? So you'll have a printout of the current roster of all your current residents, and the committee members will essentially verify the signatures unit number against that roster. Okay. Now, this is where voting certificates will come into play. If your governing documents, specifically your bylaws, require voting certificates, and voting certificates will come into play if, for example, a unit is owned by multiple owners, by multiple individuals, or a unit is owned by an entity. In those cases, your bylaws may require that all owners of the unit or an authorized officer of the entity that owns the unit fill out a voting certificate identifying basically who among the individual unit owners of the unit or which authorized officer or agent or principal of the entity is allowed to cast a vote for the unit. Okay, so if the bylaws require that and you have been enforcing voting certificates, You will have those voting certificates either at the committee meeting or on the date of the annual election, and you will use those to verify the outer envelopes. Okay. If your documents don't require voting certificates or you haven't enforced them in the past and you want to do so in the future, then I would suggest seek legal guidance on how you would do that going forward. Okay. But the, I guess the benefit of having voting certificates is, and provided you've uniformly enforced them, is that if an owner signs an out or submits an election ballot, and that owner does not appear to be the authorized voting representative or voting member for the unit, then that ballot would be disqualified. Okay. And then any outer envelope that is not signed by an eligible voter will need to be marked as disregarded or words to that effect. And then any ballots contained in those in that envelope will not be counted. One other point with regard to these impartial committee meeting is that owners are allowed to attend and owners are allowed to sit there and, watch the whole process. Okay, so this is not a closed committee meeting at all. Now, you can also go through the same verification process on the date of the annual meeting. Okay, if you don't want to do it in advance. So essentially, once you call the meeting to order, typically you'll get your volunteers and they will start with the outer envelope verification process before you start slicing through the envelopes and taking out the ballots. Also, just a quick reminder, once the election ballot is received, it cannot be rescinded or changed. And another point is, while the committee members are verifying outer envelopes on the date of the annual meeting, any member who wants to cast a ballot at the last minute can still do so. Remember, the polls close only when the first envelope is sliced open. Whenever you slice through an envelope, that's when the polls are officially closed. So until that is done, any owner can come in and cast an election ballot, even while the volunteers are verifying outer envelopes. Okay, once the outer envelopes are verified, then in the presence of the unit owners in attendance, and regardless of whether there's quorum present of the members, all inner envelopes will be first removed from the outer envelope. And then upon commencement of the opening of the outer envelope or accessing the electronic votes, whichever occurs first, then the polls will be closed and no more ballots will be accepted. Then the inner envelopes will be opened and the ballots will be removed and then counted in the presence of the unit owners. Any inner envelope containing more than one ballot has to be marked as disregarded or words to that effect. And then those ballots will not be counted. And then all envelopes and ballots, regardless of whether or not they were disregarded, they have to be retained as part of the official record. So all those envelopes that you tear through, the outer envelopes, the inner envelopes, and all the ballots, the ones that you disregarded, and the ones that you counted are all part of the official records, and you have to keep them for at least a year. Okay? Elections are decided by plurality of the votes. Runoff election rarely happens, but occasionally this may occur. So if two or more candidates for the same position receive the same number of votes, which would result in one or more candidates not serving or serving a lesser period, the association shall, unless otherwise provided in the bylaws, conduct a runoff election. So take a look at your bylaws, see if they address runoff elections. And if not, this is the typical process that you would need to follow, and it's provided for in the Florida Administrative Code. I would say before you even proceed with your runoff election, ask the candidates if one of them will want to voluntarily step down. And if not, then this is the process. So within 7 days of the date of the election at which the tie vote occurred, The board must mail or personally deliver to the voters a notice of a runoff election. Only the candidates eligible for the runoff election to the board position are the only candidates eligible for the runoff election are the runoff candidates who receive the tie vote. And then the notice shall inform the voters of the date of the scheduled runoff election and must include also the ballot and as well as copies of the candidate information sheet. The runoff election must be held no less than 21 days, no more than 30 days after the date of the election at which the vote occurred. Okay. We're almost done with condominium elections, and then we'll move on with HOA elections. But one other thing I want to point out here. This was part of House Bill 913, legislation that took effect July 1st of 2025. Electronic ballots. This will apply to your condominium if the board has not adopted electronic voting. If you have adopted electronic voting for your community, then this will not apply. Okay. So unless the association has adopted electronic voting, the association must designate an email address for receipt of electronically transmitted ballots. A unit owner can then electronically transmit a ballot to that email address designated by the association without complying with the Florida statute regarding the secrecy of ballots. Okay, so you have to designate this email address, and then the owners can choose, okay, to waive the secrecy of their election ballot. And then rather than submitting a ballot with the inner and the outer envelope system, they can simply email their election ballot to this email address. A unit owner must transmit his or her completed ballot to the email address designated by the association no later than the scheduled date and time of the meeting during which the matter will be voted on. Okay. Now, the association has to count the completed ballot that were electronically submitted to this designated email address, so long as it complies with the following requirements. So the ballot has to include a space for the unit owner to type his or her unit number. There has to be a space for the unit owner to type his or her first and last name, which functions as their signature. And then the ballot has to include the language that's here in boldface. Essentially, waiving the secrecy of the ballot is your choice. You do not have to waive the secrecy of the ballot in order to vote. And by transmitting your completed ballot through email to the association, you waive the secrecy of your ballot. So if the electronic ballot meets these requirements, you have to accept it. Another change that took effect July 1st of 25, if at least 25% of the voting interest of the condominium petition the board to adopt a resolution for electronic voting for the next election, then the board must hold a meeting within 21 days after receipt of the petition to adopt such resolution. So with electronic voting, if you recall, the board can choose to adopt electronic voting for the condominium. But it was essentially a business decision of the board whether or not they wanted to do so. Okay, and many boards over the last few years have done so, right, to streamline their voting process and whatnot. Now the statute gives owners the ability to force the board to adopt electronic voting, provided these requirements are met. Also, the board must receive the petition within 180 days after the date of the last scheduled annual meeting. But as we've just mentioned in the last few slides about the electronic ballot, you definitely want to seriously consider adopting e-voting for your community. All right, I'm going to switch gears now to annual meetings and elections for HOAs.
And folks, if you haven't already done so, be sure you press the chat button one time, simply so it appears. That's where we're going to place the link for the evaluation later. Do not worry if it says chat disabled. We can still send stuff to you. And for those of you wondering about HOA content, it's about to come up. Again, we know that there was a lot of condo stuff here, but rest assured, everything the division needs in this class is in this class. Kirsten, back to you.
Okay, so with HOA elections, the governing documents may require the board that board members may be lot owners, so similar to condominiums. There is no maximum term length or term limit. Felony conviction is, can disqualify an individual from running for the board. Also, a person who is delinquent in the payment of any monetary obligation to the association is not eligible to be a candidate. So, unlike with condominiums, it's not just assessments, but really any monetary obligation. So, if the individual has had a fine imposed against them and they haven't paid, that counts towards the delinquency. Pending charges of felony theft or embezzlement offense involving association funds will disqualify you. Co-owners are permitted to be candidates and serve on the board, unlike with condominiums. And there are no other eligibility requirements that would be in your documents that would be valid. The association has to hold a meeting of its members annually for the transaction of any and all proper business. And then the election of directors, if one is required, has to be held in conjunction with your annual meeting. Your notice of your annual election meeting, of course, has to include the date, time, and location. And unless your governing documents provide a time frame within which to provide notice, then the association must mail, deliver, or electronically transmit notices to owners no less than 14 days prior to the meeting. Okay. Again, you can also email notices to owners, but only to those who have consented to receiving official notices in writing. Big thing with HOA elections. Unlike with condominiums, which have to follow the statutory election process with the 60-day and the 14-day notice, with HOA elections must be conducted in accordance with the procedure set forth in the governing documents. Okay. So the statute has limited guidance on elections, with the exception of several points. So really, your election procedure is going to be governed by what's in your bylaws. Okay. So if, for example, you're following, and over the years, a lot of HOA associations have moved towards these condo style elections with the inner and the outer envelope and this first and the second notice. If you're currently conducting this type of election, but that process is not in your bylaws, then you subject your election to legal challenge. So speak with your legal counsel about amending your bylaws to institute the election procedure that you're currently following or want to follow. Okay. So if you're not following what's in your bylaws, then you need to amend. Otherwise, you need to follow what's in your bylaws. As of July 1st of 2013, the statute says that if the election process set forth in your governing documents allows candidates to be nominated in advance of the meeting, the association is not required to allow nominations at the meeting. So again, you have to hold nominations from the floor on the date of your annual election meeting, unless, of course, your bylaws provide for a different nomination process. Okay, in advance of your annual meeting. So if it does, then you can dispense with nominations from the floor on the date of the meeting. With HOAs, unlike condominiums, quorum must be established in order to conduct an election. So the first agenda item with HOA annual election meetings is that you have to establish quorum. And unless your governing documents provide for a lower quorum for an HOA will consist of 30% of the total voting interest. Okay, so you'll have to check your bylaws and see if you have a lower quorum requirement. If not, 30% of the voting interest of the membership has to show up in person or by proxy in order for you to proceed with your election. If you don't have a quorum at your annual election meeting, then you have a holdover board. Your board will essentially roll over for another term. Members have the right to vote in person or by proxy unless otherwise provided in the governing document. And you might have governing documents that prohibit voting by proxy for elections. Okay, so check your documents. If your documents permit voting by secret ballot for those who are not in attendance, so if your documents allow voting by absentee ballot, the statute does say that the ballot must then be placed in an inner envelope, and then the inner envelope has to be placed in an outer envelope, very similar to condominiums. Okay. And then all ballots and proxies are tabulated on the day of the annual meeting. Now, quickly, vacancies. Unless otherwise provided in your bylaws, any vacancy occurring on the board before the expiration of the term of the director may be filled by the affirmative vote of the majority of the remaining directors. And that's even if the remaining directors constitute less than a quorum or by the sole remaining director. So if, for example, you have a board of 5 and everyone has quit and there's one director left, well, you have two out of the 5 directors still on the board. You will then have less than a quorum of directors seated, right? If your board is 5. That means that you really cannot conduct association business because you do not have a quorum of the board. However, even then, the only thing that you can do is appoint enough directors to the board to at least have a quorum. Okay. So if you have less than a quorum of directors on the board, then they can still appoint enough seats to create a quorum. And then once you have a quorum, you can conduct association business. In the alternative, the board may hold an election to fill the vacancy. Now, unless your documents say something else, a board member appointed or elected to such vacancy will fill the vacancy for the unexpired term of the seated of the seat being filled. And then filling vacancies created by recall has to be done under recall statute. All right, electronic voting. I'm just going to mention quickly again. It is the board that has to vote to institute electronic voting. So that is a board decision, unless, of course, for condominiums, owners petition the board. For condominiums, it used to be that you had to notice the board meeting in which you're going to adopt electronic voting at least 14 days in advance. That has changed. So now for condominiums, if a board wants to have a meeting to institute electronic voting, you only need to notice that meeting 48 hours in advance. For HOAs, you still have that 14-day requirement. The electronic platform that you choose will have to comply with certain statutory requirements. I'm not going to go over that here, but I've listed some of those requirements here. So just make sure that you, when you're vetting the vendor, that you confirm that their platform satisfies these requirements. And then once the board ultimately adopts electronic voting for your community, remember owners have to opt into the system, right? And once they opt in, they have to be allowed to vote electronically on issues coming before the membership until they choose to opt out, okay? All right, election of officers, and we're almost done. So we've talked about election of directors. Now, officers, right, which are typically your president, vice president, treasurer, secretary, and then any other assistant officers, those are selected by the board. And typically, the meeting at which officers are elected or selected is called an organizational meeting. And typically, that organizational meeting will follow immediately after the annual meeting. Right? So once the annual election meeting is adjourned, you will proceed into your board organizational meeting, call that to order, and then elect your officers. Directors may not vote by proxy or by secret ballot at board meetings, except that secret ballots may be used in the election of officers. And there's no prohibition against changing officers midstream. So if you want to remove the president because they're not doing their job, or a treasurer, and you want to select someone else to serve in that capacity, you can do so at a board meeting. But remember, you're not removing if those officers are also directors, you're only reorganizing officers. You're not removing those individuals from the board because you can only remove directors by recall. All right, and then quickly, board certification requirements. Once a candidate has been elected to the board, these are the certification requirements as per recent changes in the law. So for condominiums, quickly, board members are required to do two things. Not only attend a division-approved board certification class, but remember, you still have the obligation to sign a certificate indicating that the director has read the governing documents and will uphold them and will meet their fiduciary duty. So two things, the certificate and then attend the board certification class. The board certification class has to be at least 4 hours long, and it has to cover certain topics, which I've included here. All board members have to attend and complete their board certification class within 90 days of being elected or appointed. The only caveat in the statute was that if a director was elected before July 1st of 2024, they were required to complete their certification requirement by June 30th of 2025. So hopefully those directors to whom this applies have already complied. And then once the director has completed the 4-hour certification requirement, each year thereafter, they are required to take continuing education courses, which satisfies 1 hour of continuing education, and it has to be essentially on updates, changes in the law. The certification is valid for 7 years after issuance, and then the association must maintain proof of the written certificate and education certificate for 7 years after the director's election. For HOAs, newly elected appointed directors have a requirement to take or complete a board certification class within 90 days of being elected or appointed. And then the director must complete that board certification class at least every 4 years, so long as you serve uninterrupted. And then once you complete the board certification class, the director has also an obligation to complete continuing education requirements. And the number of hours will depend on the size of your community. So if your community has fewer than 2,500 parcels, you have to complete at least 4 hours of continuing education annually. And then a director that serves for a community and association that has at least 2,500 parcels, then you have to complete at least 8 hours of continuing education annually. The association has to retain the educational certificates for the newly elected directors for 5 years, and then the certificates of completions are valid for up to 4 years. And then a director who does not timely file the education certificate for newly elected or appointed directors is suspended from the board, and the board may temporarily fill the vacancy during the period of suspension. Election records and disputes, and I believe that is the last slide. So any challenge to the election process, whether you're with a condominium or you're governed under we are with an HOA. It has to be commenced within 60 days after the election results are announced. A challenge can either be brought by petition for arbitration with the Division of Condominium, or can be brought as an action, a lawsuit in circuit court. And then again, just a reminder, ballots, sign-in sheets, voting proxies, and any other papers related to voting by unit owners. So it would include anything related to the voting, the election, or any other voting at the annual meeting, has to be maintained for a period of 1 year from the date of the election or vote. Notices must be maintained as part of the official records for 7 years. Okay. All right. I think that was it.
Well done. Well done. I know you got to get out of here soon. So while I do about a minute here of going over some of the housekeeping for those who want to get out of here, you don't need to stick around for the Q&A, folks. This is not the required part. The required part ends after you click on the link in the chat, fill out the survey, the evaluation, and submit it. After that, you can not only save the slides instantly, then you can go. Also, I want to thank a few people in the Q&A that were sending some suggestions on structure of the class. I've got some ideas, so I want to thank you for that. And within 5 to 7 business days, your certificates will be sent to the email addresses you used that you enter into the evaluation. Kerstin is going to now answer some of the HOA-centric questions that are in the Q&A. So again, folks, in the chat, if you haven't already done so, press the chat button so it appears, so it shows up. It's going to say disabled. Don't worry. We can still send stuff your way. So if you haven't already done that, press it, and I'll place the link in there once again in about a minute.
Okay. I'm kind of going through the questions. Some are very... some are a bit difficult to answer.
Skip the novels. Some of them are novels. Skip those.
And apologize. And some it just will require additional facts. So,
right.
For example, this one, if the bylaws say the board needs to have a minimum of 3 directors and a maximum of 7, does the board still need to vote to determine how many seats will be open prior to the annual meeting? Well, this is one of those that I hate giving this answer, but it's going to be very document specific. So I recognize your documents say no less than 3, no more than 7, and many documents say that. But then what else does it say? Is it as determined by the board from time to time, or as determined by the membership? So you'll have to confirm what else the documents say. Or, it may be that you need to amend the bylaws to decide the size of the board. So can't really give any more advice beyond that. So this question has come up for, let me see here. Hold on a second.
Lots of good suggestions in here too. Thank you, everybody.
If the bylaws allow advanced nominations and floor nominations, the HOA needs to do both. That's going to depend on how the bylaws are drafted. So if they allow nominations in advance and make the floor nominations discretionary, then seems to me that in that case you can dispense with nominations on the date of the annual meeting. If your bylaws still require nominations from the floor, I think an argument can be made that yes, you still have to proceed with those nominations, because remember your elections are subject to whatever's in your bylaws for HOAs. Let's see. I'm trying to pick your HOA related questions. How long is the recording of the annual meeting to be kept? It's 1 year. Let's see. Okay. Is
And there was a question in there that as an HR pro that's one of the things I've done in my past on the association level that I would see all the time. And it was, what if you have a manager who's bad mouthing, and this doesn't matter, HOA or condo. What if you have, what is the law if you have a manager bad mouthing certain candidates trying to sway people to vote one way or the other? Is there anything legal that you've heard of, Kirsten? Have you ever seen anything like that before or handled anything like that before?
I'm sorry, say that again. I
Oh,
was
I'm sorry,
reading.
you were reading.
No, go ahead.
If there's a manager, and it doesn't really matter HOA or condo, if there's a manager and the manager happens to be bad mouthing a particular candidate running for the board, is there anything in the law that can help combat that? I would see that all the time as an HR professional. And I'd have to get in the middle of that. That's not really it's just
I mean,
sorry,
it's
it
not
may
so
not
much
be
a legal
illegal in
question,
nature.
it's political.
Yeah. Yeah. I would just don't do it. Take everything with a grain of salt and form your own opinions, just like in real politics.
Um, how can it be a secret ballot if the inner envelopes must be opened in the view of owners that are present at the meeting? Well, it's secret in the sense that, the inner envelope goes in the outer envelope, right? So after you've verified the outer envelopes, the inner envelope is removed from the outer envelopes. Okay. Those outer envelopes should then be collected, put in a pile. That's it. So when you remove the inner envelopes, those inner envelopes, you will not necessarily know to which outer envelope it belongs to, or you shouldn't. That's the whole purpose of this inner envelope. So that's what maintains a secret. And then when you remove the ballot from the inner envelope, again, you should know what to which outer envelope it belongs. Do board members have to be seated immediately after the ballots are counted, or can there be a delay similar to a presidential election? No, with community association elections, it is the candidates are essentially seated on the date of the annual meeting. I mean, unless your documents say something completely different, that's how it should be, right? So at the adjournment of the annual meeting, you have your candidate seated. You can then proceed to your board organizational meeting. You can establish quorum, right, based on the individuals that were just elected, and then proceed in organizing your officers. There should only be one ballot in an inner envelope. If there's multiple ballots, then both are disregarded. Okay.
Those are good. The end that applies to each association type by John. Primary responsibility for maintaining the records of the education requirements for its members of the board. Is it the management company personnel, the association council, someone else, since the DBPR is not set up to maintain those records?
Well, I mean, you have to submit them to your, whoever maintains your official record. So typically if management maintains the official records, give a copy to this to your property manager. If you're self-managed, then your secretary has to keep the official records. And I would also keep a copy for yourself so that if there's any question whatsoever, you can support it with another copy.
And folks, that's why not the attorneys, I'm a pain in the butt about making you fill out the evaluations so that if you ever get challenged and it's a class that you took with us, we have the Zoom attendance sheet to help prove you were here, and we have the evaluation submission to help prove you were here. So that's why I'm kind of a nuisance when it comes to that. So don't blame Kirsten, blame me.
Our HOA governing documents define the quorum in a different place than the HOA statute reference. Does it still mean that we have a quorum defined legally? Not sure what that means, but typically quorum is set forth in the bylaws. That really is where it should be. It shouldn't be in your declaration of covenants, and it shouldn't be in your articles. I've actually never seen a quorum in the articles. So it should be in the bylaws. So whatever the quorum requirement is in your bylaws, provided it's less than 30%, that's what you go with. Okay. If your documents are silent in quorum, you default to 30%. And if your documents happen to provide a quorum that's greater than 30%, then again, you also default to the statute, which is 30%.
And you have 90 seconds, so do one more.
Who runs the annual meeting if there's a quorum of the members present or by proxies? I mean, typically, the board, right? So board members will typically attend. You don't need a quorum of the board, but the board with the assistance of management typically assist with running the annual meeting. You might also have legal counsel who can assist. That's perfectly acceptable. Okay.
Well, thank you, my friend. Went above and beyond as usual. We appreciate you very much, Kirsten, for taking the time to present the class today. Hope you have a wonderful rest of your day, and I hope to see you soon.
Thank you all. Thanks, Jeff.